Good morning, everyone. I, Kritika Goyal, warmly welcome you all to today's special webinar hosted by LiveLaw Academy. Today's session is in continuation of our yesterday's session on taking cognizance of an offence by a magistrate. If you missed the yesterday's webinar, you can watch it on our YouTube channel. Before we begin,
Again, your voice interrupts. Voice breaks.
So is it better? Yes. So before we begin, it's both my honor and my privilege to introduce the guiding force behind this session, Justice V. Ramkumar, sir, our patron and chief mentor at LiveLaw Academy. Justice Ramkumar, sir, is a distinguished former High Court judge of Kerala. Sir began his legal journey with an LLB from Government Law College, Mumbai, and enrolled as an advocate in 1979. In 1987, he was directly recruited as a district and sessions judge. Sir later served as law secretary to the government of Kerala and was elevated as a permanent judge of the Kerala High Court in 2004, a position Sir held with great distinction until his retirement in 2012. Over the years, Justice Ramkumar Sir has also served as the chairman of the advisory board under the Kerala Anti-Social Activities Prevention Act, as well as the ombudsman for the Kerala Cricket Association. He is a much sought-after speaker, regularly invited by judicial academies, law universities, and the Bar Council to address judicial officers, prosecutors, and students. His contribution to legal literature also includes acclaimed books like Law of Prevention of Corruption, Tendering Pardon to an Accomplice, and Magisterial Trials, Law and Procedure. Sir's unique Q&A style legal articles on live law have helped decode tough concepts for students and practitioners alike. And now, without further ado, let's all welcome Justice Ramkumar, sir.
Thank you, Kritika. Good morning, friends. Yesterday we had seen the 4 sources of taking cognizance of an offence, which are available to a magistrate. The first source we saw under section 210 of BNSS, corresponding to section 190 clause 1 of CRPC. Upon receiving a complaint of facts, complaint of facts constituting the offence, which is loosely called private complaint. Second source is on receiving a police report. That is, a police report is a report filed by an investigating police officer before the magistrate after the conclusion of investigation. Third, we saw under clause C that it has got 2 subclauses. Clause 1, information received from a person other than a police officer. There we noted that if an accused who has been arrested by the police and brought before the magistrate, and if the magistrate asks him, have you got any grievance against the police officer? The accused says, yes, I was manhandled by this police officer, not by this police officer, but the arresting officer, and I was very, very much ill-treated also. Then that is a complaint or information emanating from a person other than a police officer. Likewise, the police officer after investigation may file a closure report saying that no offence is made out. But then, if the magistrate peruses the record and discovers that one person has clearly stated about the offence committed by the accused, then that is one instance where the magistrate can act upon and take cognizance of the offence, notwithstanding the closure report filed by the police. Here, the magistrate is acting on an information other than that of a police officer, because this is a 161 statement or statement recorded by the police officer from a witness, and that it is the information given by the witness who is other than a police officer. So, in fact, that was held so by Abhinandan Jha versus Dinesh Mishra, AIR 1968 Supreme Court 117, where Justice Vaidhyalingam, speaking for the bench, held that this is one of the cases falling under clause 1 of subsection C of clause C of section 1 210, 191 CRPC. Then we noted that there can be extrajudicial information like letters, webinar, newspaper reports, news channel reports, internet information, etc. for vindicating justice. They are also information from a person other than a police officer. Then we saw the last clause, that is an offence committed in the very presence of the magistrate. These are the 4 sources of taking cognizance available to a magistrate. And yesterday we discussed the source of private complaint. We also noticed that the 2 main sources which usually come up for consideration before criminal courts are private complaint and police report. Yesterday we discussed private complaint. Today we will start our discussion on police report. Kritika, please read question number 11.
Yes, I'm sharing my screen as well. So question number 11.
11.
What is a police report and can there be more than one type of police report?
See, a police report is as defined under section 2(1) small t of BNSS corresponding to section 2R of CRPC is a report forwarded by a police officer to a magistrate under section 193 clause 3 of BNSS corresponding to section 173 2 CRPC as soon as the investigation has been completed. Now, a police report can be mainly of 2 types. One type of police report is where the accused is charge sheeted for the specified offences when the investigating officer is satisfied under section 190 of BNSS corresponding to section 170 of CRPC that there is sufficient evidence collected enabling him to send the accused for trial to the magistrate. That is usually called a charge sheet, final report or charge sheet, where the accused is charge sheeted. Yet another type of police report is where the accused is released by the investigating officer under section 189 of BNSS, corresponding to section 169 of CRPC, when he is satisfied that the evidence collected by him is deficient to send the accused for trial. He has not been able to collect sufficient evidence to put the accused for trial. In such case, he can release the accused, and he can be released on a bond, undertaking to appear before the magistrate as and when, if and when called. Now, the first type of police report is commonly called charge sheet or a challan. Second type of police report is commonly called refer report or a closure report or a refer charge or a final form. Now, the police report will indicate the conclusions of the investigating officer as to why he is either charge sheeting the accused or he is submitting a refer report. But a magistrate, mind you, is not bound by the conclusions of the investigating officer in the police report. Notwithstanding the opinion of the investigating officer that a case has been made out for trial of the accused for the specified offences, the magistrate, after a perusal of the materials produced along with the police report, can drop the proceedings on the ground that no offence is made out. Conversely, the magistrate may disagree with the conclusion of the investigating officer in the closure report and may take cognizance of an offence if the materials produced along with the closure report do make out such an offence. So, see, the magistrate is not bound by the conclusions of the investigating officer. Notwithstanding his view that no case is made out against the accused and he files a closure report, there might be some scintilla of evidence in the materials collected by him pointing an accusing finger towards the accused. That the magistrate can take note of and take cognizance of the offence, notwithstanding the conclusion reached by the investigating officer that there is no case made out for trying the accused. Conversely also. Now we pass on to the next question. Question number 12.
Question number 12. How does a magistrate take cognizance of an offence on a police report?
If a magistrate, after perusing the police report and the material produced along with the police report, comes to the conclusion that an offence has been made out therein, he may take the case on file, give a number, assign a number to the case, and issue process to the accused. This is a short way in which you can conceive the taking cognizance of an offence on a police report. It is not as complex as that in a private complaint. If there is plurality of offences, supposing there are more offences and plurality of offenders, more accused than one, the magistrate will have to examine as to which all offences have been made out against which all accused and proceed accordingly. Supposing there are 5 offences and 10 accused persons, and on a perusal of the entire record, the magistrate is of the view that all the offences are made out only against two accused persons. Against the other 3 persons, no offence at all has been made out by the record, even though they have been charge sheeted by the police. He can take cognizance of all the offences against 2 of those accused persons, and he need not take cognizance against the other 3 accused persons who will be deemed to have been discharged. Now we pass on to question number 13, the real mechanics of police report, cognizance on a police report.
Question number 13. Whether a magistrate is bound to take cognizance of an offence on receipt of a police report.
If you go by the wording of section 210(1) BNSS corresponding to section 191 CRPC, the expression used is the magistrate may take cognizance of the offence. But the constitution bench of the apex court in AC Agarwal Subdivisional Magistrate versus Ram Kali, AR 1968, Supreme Court, page 1, 5 judges. Justice K. Hegde, speaking for the constitution bench, held that the expression may used in section 190 clause 1 of CRPC has to be understood as shall. Therefore, when the police report alleging of the offence, alleging the offences against the accused, it has been filed before the magistrate. It has been held that magistrate is bound to take cognizance of the offence. Of course, there can be cases where no offence at all is made out. That's a different thing. But where an offence has been made out in the police report filed by the police officer, investigating police charging officer, then the magistrate has no other alternative but to take cognizance of the offence, even though the expression used is may, discretion, no discretion. He has to. Question number 14.
Question number 14, sir. What are the options available to the magistrate when a police report charge sheeting the accused is filed before him?
Now, police officer after investigation files a police report charge sheeting the accused for the offences mentioned therein. Now, I told you the magistrate is not bound by the conclusions reached by the investigating officer. If a charge sheet has been filed before the magistrate, he, after perusing the charge sheet and the materials produced along with the charge sheet, has 3 options available. He has 3 options before him. First, option number 1, he may accept the report and take cognizance of the offence and issue process, because there is an offence alleged. Therefore, he may accept the police report, take cognizance of the offence alleged and issue process. Option number 1. Then option number 2, he may disagree with the report and drop the proceedings because he does not find out any offence at all. He does not make the charge sheet does not make out any offence at all. Therefore, he is not desirous of taking cognizance of any offence. Therefore, he may disagree with the report and drop the proceedings. Third option, he may direct further investigation under section 175(3) of BNSS corresponding to section 156(3) of CRPC and require the police to make a further report. Now, he is not satisfied with the investigation conducted by the police officer. Therefore, he will direct the police officer to make a further investigation under section 156 3 CRPC corresponding to section 175 3 BNSS. I can give you some of the citations. Paragraph 16 and 17 of Abhinandan Jha versus Dinesh Mishra, AIR 1968 Supreme Court 117. I had already given the citation while discussing the clause 1 of subsection C of section 191. That is discussing the 4 sources of taking cognizance of it. The clause 1 of clause C, subsection C, that is on the information by any person other than a police officer. There, Abhinandan Jha had observed through Justice Vaidylingam that if on a police report there is material in the records about the cognizance of an offence, of the commission of an offence, the magistrate can take cognizance of offence, notwithstanding the conclusion reached by the police officer that no offence has been made out. He can take cognizance of offence. This is one such case. Then Ram Naresh Prasad versus State of Jharkhand, 2009, volume 11 SEC 299. Judges are Dr. Arijit Pasait and Dr. M.K. Sharma. Dr. Arijit Pasait being the author of the judgment. Again, Kishore Kumar, Gyan Chandani versus G.D. Mehrotra, AIR 2012 Supreme Court 483, corresponding to 2011 volume 15 SEC 513. Then again, Popular Muttaya versus State, 2006 volume 7 SEC 296. Justice S.B. Sinha is the author. So in all these cases, the apex court held that notwithstanding the conclusion reached by the investigating officer, those conclusions are not bound by the magistrate is not bound by those conclusions. And despite those conclusions reached by the investigating officer, magistrate can decide otherwise, provided there is material to justify the view taken by the magistrate. Question 15.
Question 15. If what has been filed before the magistrate, the closure report / refer report or refer charge or final form, what are the options available to the magistrate?
In the earlier question, we discussed what are the options available to the magistrate when the police file a police report charge sheeting the accused. Now, this is a case where police report is filed stating that no offence has been made out and therefore a closure report has been filed. What are the options available to the magistrate? Same options. After perusing the closure report and material produced along with the closure report, the magistrate has 3 options. 1, he may accept the report and drop the proceeding because the report is closure report. He is accepting that closure report, dropping the proceeding. Second option, he may disagree with the report and ignoring the conclusion drawn by the police, he may independently apply his mind to the facts emerging from the investigation and take cognizance of the offence which is revealed by the material on record and may issue process. Second option. Last option is he may again, as in the earlier case, he is not satisfied with the investigation conducted by the police officer. Therefore, he may again order further investigation under section 175 3 CR BNSS corresponding to section 156 3 CRPC and direct the police to file a further report. A supplementary report may be filed. Again, Abhinandan Jha versus Dinesh Mishra. Then H.S. Baines versus State of UT of Chandigarh, AIR 1980 Supreme Court 1883. Justice Chinnappa Reddy and R.S. Sarkaria. Then Bhagwan Singh versus Commissioner of Police, AIR 1985 Supreme Court 1285. 3 judges, P.N. Bhagavati, author of the judgment. This is a very well considered judgment. In fact, this judgment is very often quoted before criminal court because when a police file a refer report And if the magistrate is going to accept the refer report, who is aggrieved by that? When a closure report is filed by the police, and if the magistrate is going to accept the closure report, who is the person aggrieved? The first informant. The first informant who set the criminal law in motion and who alleged the commission of an offence by the accused, he is going to be affected. Therefore, Justice P.N. Bhagwati, speaking for the three-judge bench, held that before accepting the closure report, the magistrate should issue notice to the first informant. He is the person entitled to notice because you are prematurely terminating the proceedings behind his back. He had set the criminal law in motion, but without his knowledge, you are going to terminate the proceedings saying that no offence is made of. So give him notice. It is not written in the CRPC or any law. It is a judge-made law for a very noble purpose. Again, other decisions are India Carrot Private Limited versus State of Karnataka, AR 1989, Supreme Court 885. Then any number of decisions are there on this point. When I am giving the notes, I will incorporate all those decisions. Now we may pass on to question number 16.
Question number 16. On receiving a closure report, if the magistrate is exercising the option of accepting the closure report and dropping the proceedings, is there any legal formality to be followed by the magistrate?
I have already answered this. Yes, there is a legal formality. When a closure report is submitted by the police, the magistrate, before taking any action on the report, must give notice to the first informant or complainant and furnish him with copies of all statements of witnesses and other related documents and the investigation report. After perusing the report, he may say, I have no objection because what has been concluded by the investigating officer is correct. Or supposing he says that investigating officer has been dishonest and he has suppressed important information, important material, he may say that I object to the closure report. Cognizance may be taken. These are the materials available in the police report. He can say that. The earliest occasion when the Supreme Court said so was Vasanti Dubey versus State of Madhya Pradesh, 2012, Volume 2, SEC 731. The judges were A.K. Ganguly and Gyan Sudha Mishra. Gyan Sudha Mishra was the author of the judgment. Then came the celebrated judgment by Justice P.N. Bhagwati. Bhagwan Singh versus Commissioner of Police, AIR 1985, Supreme Court 1285. It was followed by Union Public Service Commission versus S. Papaya, AIR 1997, Supreme Court 3876. Dr. A.S. Anand and K. Venkataswamy. Again, just Sanjay Bansal versus Georgerla Watts, AR 2008, Supreme Court 207. Dr. Arijit Pasayat and Lokeshwar Singh Panda held that the magistrate is bound to give notice to the informant if he decides not to take cognizance and not to take, and as regard, supposing he takes cognizance against some of the accused and refuses to take cognizance against some other accused, then also he has to give notice to the first informant. This was the decision. Arijit Pasayat. There's a one Kerala decision by Justice Narayana Pishareddy, wherein that is Vishnu Kumar, that is Manikandan versus State of Kerala, 2019, 5 KHC 722, wherein it was held that notice is a victim who was not the first informant. See, the first informant is the person who set the criminal law in motion. He need not necessarily be the victim. Therefore, if the victim is not the first informant, the person who is entitled to notice is the first informant, not the victim. But then, being the victim, the court cannot shut out the victim from addressing the court. If the victim approaches the court and says, I have got objection to the closure report, court will certainly hear the victim. Though notice is not to be given to the victim, but only to the informant who set the criminal law in motion. Now, there's one decision by Justice K. M. Joseph also. Vishnu Kumar Tiwari versus State of UP, AR 2019 Supreme Court 3482. 2019 Supreme Court 3482. That is same principle. That is, all the three options are available to the magistrate when a closure report is filed. Now we pass on to question number 17.
Question number 17. On receiving a complaint alleging both cognizable and non-cognizable offences, the magistrate forwarded the complaint to the police for investigation under Section 175(3) BNSS, that is Section 156(3) CRPC. The police filed a closure report before the magistrate. Can the magistrate take cognizance of the offence either on the closure report or on the original complaint?
Here the facts are slightly different. A private complaint is filed before the magistrate, alleging cognizable and non-cognizable offences. The magistrate forwards the complaint to the police for registering an FIR and conducting investigation. The police officer registers an FIR, conducts investigation, and after investigation files a closure report. Now the question is, which is the material on which the magistrate can, if at all, can take cognizance of the offence? Is it on the closure report or on the original complaint filed before the magistrate and which was forwarded to the police for investigation? Now this the H.S. Baines versus State of H.S. Baines versus State UT of Chandigarh, AR 1980 Supreme Court 1883. Justice Sarkaria and O. Chinnappa Justice O. Chinnappa authoring the judgment. It was held that if the refer report is filed in a matter which was forwarded under Section 175(3) BNSS, that is 153 CRPC, the option of taking cognizance of the offence can be exercised by the magistrate either on the basis of the police report under Section 210(1), that is under Section 191B CRPC. You see, under Section 191B corresponding to 210(1), the cognizance can be taken first on the private complaint, number 2 on police report. B. 191(1)(a). 191(a) is private complaint on which cognizance can be taken. 190 clause 1(b) is the source on which is the police report on which cognizance can be taken. The judges held that cognizance can be taken either on the complaint under Section 191(a) or on the closure report under Section 191(b), where provided there is material to show that there is an offence has been committed. This was the judgment. Again, there is another judgment also to the same effect. Earlier judgment, Tularam versus Kishore Singh, AR 1977 Supreme Court 2401. AR 1977 Supreme Court 2401. Justice Fasal Ali and Kailasam. Justice Fasal Ali and Kailasam. We pass on to question number 18.
Question number 18.
Yes.
Whether cognizance taken on an incomplete police report vitiate the proceedings?
Now, what has been filed before the court is an incomplete police report. For example, if all of you know that when the police are filing a final report before the court, they have to file the entire material mentioned in Section 173 to CRPC. 173(5) says, Section 173(5) corresponding to Section 193(5) BNSS say which all documents should accompany the police report. Supposing the police report is deficient in certain documents, or it should, supposing there are 5 accused persons, the police have to file a original police report with 5 copies to be given to be furnished to the accused, while the magistrate is complying with Section 207 CRPC. 5 copies also have to be filed. Supposing the police report is filed with only 3 copies, it is an incomplete police report. The police report filed without without some of the documents. It is also an incomplete police report. And the question was before the Supreme Court, before a 4-judges bench of the Supreme Court, was whether such an incomplete police report, whether cognizance can be taken on such an incomplete police report. What the court said was, 4-judges bench, though it is incomplete, if it contains sufficient materials for the magistrate to take cognizance of the offence, then it is a complete report so far as the magistrate is concerned, and within the meaning of section 210 1B BNSS, responding to section 191B CRPC, and the magistrate will be justified in taking cognizance of the offence, notwithstanding the fact that it is an incomplete police report. Incomplete in the sense that 1 or 2 inconsequential documents are missing in the report. That's all. The magistrate can direct the officer to produce those documents also. But even without those documents, if the magistrate is able to take cognizance of the offence, he cannot reject the police report saying that it is incomplete. Very important view, very vital decision by 4 judges, mind you. Tara Singh versus State, AIR 1951, Supreme Court 441. The author of the judgment is Justice Saeed Fazal Ali. Very important judgment. Yes. Question 19.
Question 19. Can a magistrate who does not have territorial jurisdiction to try the case take cognizance of the offence?
This is a situation where I have some reservations about a judgment rendered way back in the year 1999 by a 2-judges bench. Going by the verdict of the Supreme Court in Trison's Chemical Industry versus Rajesh Agarwal, 1999, Volume 8 SEC 686, corresponding to AIR 1999, Supreme Court 3499. A magistrate taking cognizance of an offence need not necessarily have jurisdiction to try the case as well. This is what the Supreme Court held in that case. The Apex Court observed that the provisions of sections 177 and 179 CRPC, corresponding to sections 197 and 199 of BNSS, do not trammel the powers of the court to take cognizance of the offence. With utmost respect, I find myself unable to agree with this view. According to me, the magistrate who can take cognizance of the offence should be the magistrate having jurisdiction to try the offence or jurisdiction to conduct inquiry and trial. I will refer to some of the sections in the CRPC, BNSS, to demonstrate my point. Section 156(1) CRPC, corresponding to section 175(1) BNSS, says or declares that the territorial jurisdiction of an officer in charge of a police station is co-extensive with that of the appropriate court which is competent to try the offence. See, under Chapter 13 CRPC, it contains certain sections wherein certain the appropriate court who is having the jurisdiction to conduct inquiry and trial has been mentioned. Those courts, it is the jurisdiction of a police officer to register an offence, to register an FIR and conduct investigation is co-terminus with that of the jurisdiction of the court which is competent to try the offence. Both are similar. In fact, if the police station does not have jurisdiction, the court does not, rather other way around. The court does not have jurisdiction to try the offence. The police station does not have jurisdiction to register the FIR or conduct the investigation, except in one or two situations. I will mention that. Now, 156.1 declares that the territorial jurisdiction of an SHO is coextensive with that of the appropriate court, which is competent to try the offence. In fact, there is one decision by myself in TP Nandakumar versus State of Kerala, 2008 Criminal Law Journal 298. Chapter 13 CRPC decides which court shall conduct the inquiry and trial in respect of an offence. Ordinarily, it is the court within the territorial limits of which the offence was committed which can try the offence. Supposing the offence was committed within the territorial limits of Magistrate A and not within the territorial limits of Magistrate B, then Magistrate A alone can take cognizance and try the offence, conduct inquiry and try the offence by virtue of Chapter 13 CRPC corresponding to Chapter 14 BNSS. Second section, Section 157.1 CRPC corresponding to Section 176.1 BNSS mandates that the SHO, after registering an FIR in respect of a cognizable offence, send a report of the same to the magistrate empowered to take cognizance of the offence. So there is a magistrate empowered to take cognizance of offence, not any magistrate. Therefore, there is a magistrate empowered to take cognizance of offence. That is the magistrate who is empowered to conduct inquiry and trial under Chapter 13 of CRPC, that is corresponding to Chapter 14 of BNSS. So it is to that magistrate that the police officer shall, after registering the FIR, send the report to the regarding the same. Then comes Section 162.2 CRPC corresponding to Section 181.2 of BNSS. Even when an accused person produced before the nearest magistrate under Section 167.1 CRPC, that is 187.1 BNSS, can only give the first remand under Section 167.2 CRPC, that is 187.2 BNSS. If such person is to be granted bail, he has to be forwarded under Section 167.2 CRPC corresponding to Section 187.2 BNSS to the magistrate having jurisdiction to try the accused and commit him for trial. See, even under Article 22 of the Constitution as well as Section 167 of CRPC, that is 187 of BNSS, a person arrested by a police officer should be produced within 24 hours before the nearest magistrate. Nearest magistrate need not necessarily be the jurisdictional magistrate having competence to conduct inquiry or trial. Nearest magistrate, because the rights of the accused is the rights of the arrestee. The rights of the arrestee is being protected by the constitution makers to ensure that within 24 hours he gets the protection from a magistrate, whether he be the jurisdictional magistrate or not. That is why under Article 22 of the Constitution of India as well as under Section 167 of CRPC corresponding to Section 187.1 of BNSS, the arresting officer should produce the accused before the nearest magistrate within 24 hours. Nearest magistrate cannot grant bail. Nearest magistrate can only remand the accused to police or judicial custody. That's all. So, but if the nearest magistrate feels that this accused need not be remanded, the fit case where he should be granted bail, then 167.2 CRPC corresponding to Section 187.2 BNSS says that if he is not the nearest magistrate, he shall forward the accused to the magistrate having jurisdiction to try the offence or jurisdiction to commit the case for trial. If it is a sessions case, it's a case exclusively triable by a court of session. This is the third section. Then we come to Section 169 CRPC corresponding to Section 189 of BNSS. See, in a case where it appears to the station house officer that there is no sufficient evidence or reasonable ground of suspicion to justify the forwarding of the accused to the magistrate, he has conducted investigation. he could not collect sufficient material to put up the accused for trial. In such a case, he has to forward a report, release the accused with a bond after executing a bond, and forward a report to the magistrate empowered to take cognizance of the offence and try. So there is a magistrate empowered to take cognizance of the offence and try. So it cannot be sent to any magistrate. Supposing the offence is committed in Kerala, the magistrate cannot send the SHO cannot send a report to a magistrate in Punjab or Delhi. It has to be sent to the jurisdictional magistrate. Then again, in a case where there is sufficient evidence to place the accused for trial, the SHO shall forward the accused under custody to a magistrate empowered to take cognizance of the offence and try the accused or commit him for trial. Therefore, the accused should be sent by the investigating officer after the conclusion of investigation to that magistrate who is empowered to take cognizance of the offence. So there is a magistrate empowered to take cognizance of the offence, not any magistrate. Therefore, the view taken in Trison's chemical industry that any magistrate can take cognizance of the offence with utmost respect does not lay down the correct law. Then comes section 173(2)(1). Section 173(2)(1) corresponds CRPC corresponding to section 193(3)(1) of BNSS. As soon as the investigation is completed, the SHO shall forward to the magistrate empowered to take cognizance of the offence on a police report, a report in the form prescribed and incorporating the details enumerated in section 173(2)(1) CRP. Therefore, this is the final report, charge sheet or refer report. This has to be filed before the magistrate empowered to take cognizance of the offence. So there also the magistrate is qualified by magistrate empowered to take cognizance. So he is a magistrate who has been empowered to take cognizance of the offence, not any magistrate. Question number, then the next section, section 201 CRPC corresponding to section 224 BNSS. In the case of a private complaint also, section 201 CRPC envisages a situation where a complaint is made to a magistrate who is not competent to take cognizance of the offence. So there is, see, section itself says if the complaint is filed before a magistrate who is not competent to take cognizance of the offence. So there is a magistrate competent to take cognizance of the offence, not any magistrate. And if a private complaint has been filed before a magistrate who is not competent to take cognizance of offence, who is not the jurisdictional magistrate, then the magistrate can return the complaint for presentation before the proper court. This is what section 201 B CRPC says, corresponding to section 224B of BNSS. Then not over. One more section, section 204(1) CRPC. That is section 227 BNSS. It is the magistrate taking cognizance of the offence and who is entitled to form an opinion that there is sufficient ground for proceeding who can issue summons or warrant, issue process to the accused. We have discussed this yesterday. We saw sufficient ground for proceeding. We saw that in under 3 sections, did not? One was 202, then other was 203, where the complaint can be dismissed. 202 is the inquiry. An inquiry is conducted by the magistrate after taking cognizance to find out whether there is sufficient ground for proceeding. Likewise, the magistrate can dismiss the complaint only if he is of the view that there is no sufficient ground for proceeding. Likewise, after taking cognizance and after conducting an inquiry, the magistrate is of the view that there is sufficient ground for proceeding, he can issue process under section 204 CRPC, that is 227 BNSS, only if there is sufficient ground for proceeding. Therefore, without sufficient ground, the magistrate cannot proceed. Therefore, for proceeding for what? Only the magistrate having jurisdiction to take cognizance of the offence, conduct an inquiry or trial, who can proceed further? Who can find sufficient ground for proceeding, for issuing summons? Therefore, going by section, and as I already told you, going by section 177 CRPC, corresponding to section 197 BNSS in chapter 13 of CRPC, chapter 14 of BNSS, every offence shall ordinarily be inquired into and tried by the court within whose local jurisdiction the offence was committed. If the offence was committed within the local jurisdiction of a particular magistrate, that magistrate alone can take cognizance, conduct inquiry, and conduct trial. No other magistrate. Apart from section 77 CRPC, there are other sections also in that chapter, which will have to be referred to for deciding the jurisdiction of the court competent to conduct inquiry. Now, my conclusion is that if Trison's chemical industry is followed, of course, so long as it is not overruled, we are all bound by that ruling. But if it is strictly followed, an offence committed in Kanyakumari in Tamil Nadu, then a magistrate sitting in Delhi can take cognizance of the offence. It will be disastrous consequences. Therefore, with due respect, and I am not inclined to accept that verdict in 99 Supreme Court. So far, no, the Supreme Court has not, a larger bench of Supreme Court has not examined the correctness of that ruling. Yes, we pass on to the last question of the day.
Question 20, sir. What is the feasibility of filing a writ petition under Article 226 of the Constitution of India against an order taking cognizance of an offence?
Nowadays, Article 226 of the Constitution of India is invoked for anything and everything. As if the High Court has got jurisdiction on any matter under law, under the sun. It is not entertainable. A writ petition against taking cognizance of an offence by a magistrate is not, writ petition cannot be entertained. Such an order can be challenged only by recourse to the revisional jurisdiction under section 397 CRPC or under the inherent power of the High Court under section 482 CRPC. Doctrine of forum non-convenience. Doctrine of forum non-convenience has been discussed in that decision by the Supreme Court. Musharraf Hussain Khan versus Bhagirath Engineering Limited. AIR 2006 Supreme Court 1288 by Justice S.B. Sinha and Justice P.K. Balasubramaniam. Justice S.B. Sinha is the author of the judgment. The doctrine of forum non-convenience, or otherwise called doctrine of forum inconvenience, is that an appropriate forum, even though competent under the law, may divest itself of jurisdiction if for the convenience of the litigants and the witnesses, it appears that the action should proceed in another forum, in which the action might also have been properly brought in the first place. Where an action has been, action has been taken in a particular forum, and if the High Court or the Supreme Court is approached, then they will say, no, let the matter proceed before that forum. It is more convenient for the litigant and the witnesses, parties, etc. This is the doctrine of forum non-convenience or forum inconvenience. Doctrine of forum inconvenience. Applying this doctrine, the Supreme Court said that the taking cognizance of offence, writ petition cannot be maintained. You can at the best file a revision petition, because under the revisional jurisdiction of the High Court, the legality, regularity or correctness of the order taking cognizance can be challenged. Or if that is not possible, in fact, that can be challenged even before the Court of Session. Court of Session is also having concurrent jurisdiction. If Court of Session cannot be, if the party or his counsel does not want to approach the Court of Session, they can approach the High Court under section 482 CRPC, but never under Article 226 of the Constitution of India. This is what the Supreme Court said. 226 it should not be invoked in each and every case. When there is in fact, there is one more principle. When there is a specific provision entitling the party to have redress, then that provision alone should be invoked, not the inherent power. Inherent power also may not be available if the other power is other. According to me, even say, at least all criminal codes should be given inherent power, so that if they make any mistake in procedural mistake, they can rectify that. It can be otherwise every party, every litigant will have to rush to the High Court for justice. Is it I don't think it is necessary. The such power can be conferred on the every criminal court, or at least the sessions judge, so that the mistake is committed by a magistrate, the nearest session judge can be approached. Why go to the High Court, which is miles away, and you have to engage an advocate of the High Court? So much expenses for the ordinary litigant. With that, I think we will conclude today's session. If there are any questions, I will, with the best of my knowledge, ability, and capacity, I will try to answer.
So while we give students the time to type out their doubts in the comment section, so I would like to make a very tiny announcement that LiveLaw Academy has launched a boot camp for 7 days and also a scholarship test for its judicial services examination preparation course. So the scholarship is tomorrow. The scholarship test is tomorrow at 12 noon. You can register by calling on the number provided in the description box. If anyone has any doubts, they can please put it in the chat box. We will be taking doubts now.
Or otherwise, they can put it in the chat box. And you can forward it to me. I will answer them and we will read it out in the next session on 23rd. Is that enough?
Certainly, sir.
Okay.
So with this, we come to an end. And thank you so much, sir. A very heartfelt thank you to all for joining in and being such an inquisitive audience. Most importantly, we express our deepest gratitude to you, sir, for not just walking us through the statutory framework and judicial precedents, but also for highlighting the whys and whats behind the entire topic. So for clarity, generosity in sharing your wisdom, it continues to inspire us. Thank you so much, sir.
You're welcome.
Thank you so much, sir. Have a great day. Thank you, sir.
Thank you.